Hello, everyone, and welcome back. If you've been dreaming about moving to Canada as a skilled worker, or if you've already tried and hit a wall with a refusal or delayed application, this video is for you, and you may want to watch it all the way through. Because right now, Canada's immigration system is going through one of its most significant transformations in years. And if you understand what's happening and position yourself correctly, this could be the best window of opportunity you've ever had. Let's get into it. So firstly, why Canada is still the destination. Let's start with the big picture. Canada remains one of the most sought-after destinations for skilled workers anywhere in the world, and for good reason. Canada offers a high standard of living and world-class healthcare, a genuinely multicultural society that welcomes newcomers, a clear, structured pathway from skilled worker to permanent resident to citizenship, strong labor market demand across multiple industries. And here's something important to understand. Even as Canada adjusts its overall immigration targets to what the government calls sustainable levels, it remains firmly committed to attracting highly skilled, economically contributing immigrants. The door isn't closing, it's being recalibrated. So, what is Express Entry and why does it matter to you? Express Entry is Canada's primary system for managing applications under its federal skilled labor programs. It's the main highway to permanent residence for skilled workers from around the world. Right now, Express Entry manages 3 federal programs. The Federal Skilled Worker Program for internationally trained professionals, the Federal Skilled Trades Program for qualified tradespeople, the Canada Experience Class for those who already have Canadian work experience. The system uses a point-based ranking called the Comprehensive Ranking System, or CRS, to score candidates and issue invitations to apply for permanent residence through regular draws. If your score is competitive enough, you get invited, you apply, you become a permanent resident. That's the Express Entry pathway, and it's about to change in ways that could directly benefit you. The proposed reforms. Here's what might be coming. Immigration, Refugees and Citizenship Canada, or IRCC, has launched a formal stakeholder consultation process on a series of proposed reforms. These are not yet finalized and no implementation date has been confirmed, but the direction is clear and the changes are significant. Here's what's on the table. Proposed change 1, a unified program. The government is proposing to merge all 3 programs, FSW, FST, and CEC, into a single unified federal high-skilled immigration class. Why? Because under the current system, the 3 programs were originally designed before Express Entry even existed. Today, they function mainly as eligibility thresholds. The real selection happens through CRS anyways. Merging them reduces complexity and makes the system more transparent. Under the proposed unified program, the new minimum requirements would be as follows. Education, a Canadian high school diploma or equivalent with a confirmed educational credential assessment. Language, CLB or NCLC level of 6 across all language areas. Note this is lower than the current FSW requirement of 7, which means more people could qualify. Work experience as well, 1 cumulative year in 1 or more tier 0 to 3 occupations within the last 3 years. And this can be Canadian or foreign experience. A job offer, no longer minimum threshold requirement of 67 under the FSW selection grid would be eliminated. For many skilled workers who were previously stuck outside eligibility, this is a game changer. A second proposal is a recalibrated point system. The CRS itself is being restructured based on new government research identifying factors actually predicting long-term economic success in Canada. Here's what the research found. The strongest predictors of economic success are earnings from Canadian work experience, official language proficiency, Canadian work experience, job offers in high-wage occupation, education, and age. The weaker predictors, which are proposed for removal or significant modification, include spousal attributes, French language proficiency, studying in Canada, and having a sibling in Canada. So what does this mean practically in terms of what's staying and what's getting stronger? Age, education, language scores, no substantive change proposed. Canadian work experience being restructured into a new labor market integration factor that combines Canadian experience with high-wage occupation experience or a job offer. Skills transferability maintained with enhanced recognition for Red Seal qualifications. Now, what's being reduced or removed? The 600-point provincial nomination bonus, proposed for removal or modification, and also removal of French proficiency points for removal, and similarly points for studying in Canada, possibly to be removed, and having a sibling in Canada bonus, that bonus might be removed as well. Spousal points, also proposed for removal or some modification. And what's being newly introduced? A high-wage occupation factor awarding points for Canadian experience or job offers in occupations that earn above the national median wage, with tiered thresholds at 1.3, 1.5, and 2 times the national median. A regularly updated list of eligible occupations would accompany this. The bottom line, the new system rewards candidates who are highly proficient in English or French, well-educated, and working or positioned to work in well-paying Canadian occupations. If that describes you, or if you're working toward that profile, your prospects under this new system could be significantly better than under the current one. So, what this means if you have a refusal or delayed application. Now let's talk directly to those of you who have already tried and were refused, or whose application has been sitting in limbo for months or even years. First, hear this clearly. A past refusal or current delay does not disqualify you from a fresh start necessarily. Here's why. If you were refused under the old eligibility criteria, for example, because you did not meet the FSW 67-point grid, or your language skills fell short of CLB 7, the proposed new framework may make you eligible where you were not before. If your application is delayed, there are legal tools available to compel IRCC to act, including applications to the Federal Court for Mandamus, which is the court order requiring a decision to be made. And if your refusal involved errors in how the officer assessed your case, there may be grounds for a legal challenge. Every case is different, but the point is this: options exist, and the evolving policy landscape may open doors that previously appeared firmly shut. So now, why professional legal advice and guidance is non-negotiable right now? I want to be very straightforward with you here. The express entry reform is still in the consultation phase. The final regulations have not been published. The implementation timeline is unknown. What the government is signaling and what ultimately becomes law can differ, and the details matter enormously. This is precisely the moment where having an experienced immigration lawyer is not a luxury, but a strategic necessity. You need someone who is actively monitoring these proposed changes as they develop, able to assess whether your profile benefits more from applying now under the current rules or waiting for the new framework, being equipped to challenge a refusal or push for movement on a delayed application. Experienced also in building applications that hold up under officer scrutiny. This is not the time for guesswork or generic online advice. So, in terms of what you have to do, if you are serious about immigrating to Canada as a skilled worker, whether you're starting fresh, rebuilding after a refusal, or trying to get answers on a delayed application, reach out to Chowdhury Law Office today. The team at Chowdhury Law Office brings real expertise to real cases. We understand the current express entry system. We're watching these proposed reforms closely, and we know how to navigate the complex intersection of immigration law, policy change, and individual circumstances. Whether your situation is straightforward or complicated, whether this is your first application or your second attempt after a refusal, You deserve legal guidance that is current, precise, and genuinely invested